Mr. Chairman, ladies and gentlemen of the committee, HB2695 would allow Virginia victims of a number of crimes, or witnesses to those crimes, to enjoy the same victim-witness privileges that victims witnesses of other crimes receive in Virginia. It's a bill strongly supported by the Commonwealth Attorneys Association and by those who provide these programs. You'll be hearing from them in just a minute. They've been very patient and been here all day. Basically, Section 19.2-11.01 is sort of the Victims' Bill of Rights in Virginia, and it provides a number of very important protections to victims and witnesses of crime. It gives them protection from harm. It allows them to have all the information they need to protect themselves from harm. It gives them the right to privacy, so their information is not turned over to the perpetrator. Protection from intimidation, confidentiality, notification. Very importantly, it allows them to write victim impact statements to say how crimes have harmed them. They have the right to remain in the courtroom during a criminal trial. They are asked their views about disposition of the case and a number of things. The code provides this already to victims of sexual battery and assault and battery, a number of things. It does not provide protection to victims of identity theft, victims of brandishing a firearm, victims of indecent liberties, which is basically someone exposing themselves, victims of threats. The Commonwealth attorneys and victim witnesses want to provide these services.
Is there a substitute? Anybody? You were chair, tells me there's a substitute. Okay, go ahead. We just want to make sure we're looking at the right thing.
Yeah, no, so basically they want to provide these services, not only do they already do provide these services, their concerns are, and they've already seen some of these, you'll hear from them, are that a perpetrator would say, you can't be in the courtroom, you don't get privacy, you don't get confidentiality, your specific crime isn't included already in Virginia code. We've already seen some defendants bringing that up. They want to provide to these victims of crime the same protections to other victims of crime, and I'll let them explain to you further unless there are questions.
Bill?
Mr. Chairman, some of these are already felonies, aren't they?
These are misdemeanors that have been included.
Not DUI, but name, isn't it?
Oh, the maiming was moved. I don't know why LIS moved it. Maiming was already there, but the identity theft, brandishing a firearm, indecent liberties, indecent exposure, using profane, threatening language over the telephone, I believe are all misdemeanors. But they could probably answer your question better than I could.
The maiming was moved for clarity with the code section numbers. Those aren't there.
Maiming was already there. The others are in.
But I still don't understand why you look at it.
Their choice. I don't care whether maiming is moved or not.
Okay, so person who has suffered harm from a felony, comma, maiming another for DUI.
Right, maiming is down below. As you see, they crossed it out and they moved it. I don't know why they moved it. I have no.
I'm not. Isn't that a felony? I'm being So why is it?
It was already in the code. If you look down, about 4 lines
I see
below.
it. Just wondering why we would.
Why not strike it now? Just strike it.
Leave it alone or fix it, but don't move it. And, it means something when we do things and stuff.
Why not just strike clause B?
Well, not clause B, but the first few lines of maiming of another resulting in driving.
24, 325.
Exactly.
Mr. Chairman, the original writing of the bill, felony wasn't included, maiming was included. So whenever felony was added, it didn't remove taken from it.
Okay. Counsel? Just your thoughts generally.
The one issue I see with this bill is the definition of victim is used 21 times, refers to this section in the code. It's used in places like juvenile confidentiality or the witness exclusion rule, in the CSCF funding. And so changing this definition changes that definition 21 other times in the code. and there's a lot of thought's been put in, I'm sure, into what's been included in this. And all of the code sections that are referred to are misdemeanor code sections, except for in the case of brandishing. ID theft could be a felony depending on the second offense, or if it's, the violation is over $500 worth of financial damage, or brandishing third offense could be a felony. But the rest of them are misdemeanor. And again, you're adding these things 21 different places in the code.
Mr. Chair. So, I mean, this is the kind of list we come up with on the fly. I'm not, where did this list come from?
It came from Autumn Jones and the Commonwealth's Attorney's Office, and they can explain to you why they came up with this list.
You guys prepared to say that it's, these misdemeanors are the right ones, the other ones are the wrong ones, you've gone through the entire list of 4,000 misdemeanors, and we don't have to make it perfect, but.
Mr. Chair, Delegate Bell, Brian Porter, Counselor of the City of Alexandria, here on behalf of the Virginia Association of Counsel's Attorneys. We do support the bill, but that language did not come from BACA. I'm not sure why only those misdemeanors were selected, but that was not our instruction or our instigation. We just support it because it does expand the protections in the Code of Victims for certain misdemeanors, but it wasn't our language. I'm not sure where it came from.
Mr. Chair. Delegate,
Brian, what's the policy implication of just saying misdemeanors generally?
Mr. Chair, Delegate Mullen, the answer is that would obviously expand considerably that term to the 21 different code sections that Council cited a few minutes ago. Practically speaking, the ways that this would actually impact us in the courtroom would be, I think, two main ways. One, witness exclusion would be able to move to have the victim remain in the courtroom for certain misdemeanors, or if we included all misdemeanors, any misdemeanor case. And also victim impact testimony. That's really where it would be a big difference from our perspective. So if the pleasure of the committee were to switch it to all misdemeanors, I don't believe BACA would have a problem with that, but we are supporting the bill that's currently written because it's expanding into certain victim-centric crimes.
I guess, Mr. Chair, follow up. I understand that it could change it in code sections, but for practical purposes, don't most Commonwealth attorneys deal with this on a victim-by-victim basis anyway, if you need extra help?
Well, my understanding is, at least in Arlington, certain judges are reading the code section, the definition of victim specifically to include only the crimes that are listed in certain cases, and not allowing victims to have a larceny or identity fraud or certain other misdemeanor offenses to have the protections that are outlined in the code. So by codifying, we can take care of that problem.
Mr. Chair, one final question, maybe this is for council more than anything else.
Okay.
What would be so bad if we just said felony or class 1 misdemeanor?
Mr. Chairman, I think the big one that I would pick out is how this is changing is the exclusion of witnesses. The law says that person denied as a victim shall be exempt from this rule as a matter of law unless the exclusion of otherwise required. So you're changing the burden from automatically should be excluded from the courtroom to now it's basically on the burden of the defendant to prove that this impairs the fairness of the trial that has the victim in the courtroom. And a lot of times when you have these misdemeanors, you track cases a lot as I do, the exclusion of the witnesses in these citizen complaints are important in making a fair trial. And so to add every single class 1 misdemeanor, you're turning that presumption that witnesses should be excluded from the courtroom to a presumption that every victim should stay in the courtroom.
So just while I'm sitting here looking at this, I'm seeing things that I would want to add to it. Let's keep in here. Violation of protective order.
That's okay.
This is the kind of thing on the fly we do very badly. I've been pushing back against every request that says that the crime commission so far, because people act like the crime commission can magically make a policy decision go away and come up with a compromise that doesn't exist. It can't. what can do quite well is kind of list of 4,000 considered career crimes, and again, I'm not adverse to the idea, I'm not sure we have a good grip on the other 21 places in the code and how expanding this, like, this could bankruptcy ICF, you know, that's a big deal. In other words, if this is in fact where we identify where the injury compensation fund money can be allotted to, we just had a bill earlier that expanded the height of it, this would expand the width, perhaps, I don't know. Mr. Chair, I would suggest that we send this to the Crown Commission. I think this is actually a good idea. This is something we can work on. But coming up with a list of how we should expand the word victim seems to be right in the wheelhouse. It's something they can work on without having to be 10 or 6 and us going through the code.
I think if you meant harm, it would sound a lot more creative than it actually came out, so.
I never go on, but it's.
Right, so.
That may well be where it should go. I do would like Autumn Jones.
No, I'd love to hear from her,
This is
the
not
Crime
just
Commission
a
is
good idea.
great
It's
at making lists and excluding lists and stuff like that. Anyway, yes ma'am, please, we'd love to hear.
Yes, my name is Autumn Jones. I'm the Victim Witness Program Director for Arlington County Commonwealth Attorney's Office, and my Commonwealth Attorney deals in with support HB2695. I did actually come up with this list. While I would love to include more misdemeanors, and I certainly understand that there are more misdemeanors, these are the ones that we see most often, and 3 specific rights that are not given to victims that we deal with on a daily basis are the rights for confidentiality. We expect victims to come in, we subpoena them, but we cannot give them any assurances that their telephone and address can be kept confidential. They don't have the right to remain in the courtroom as the victims that are stated in the code. And in terms of victim impact statement, they are not afforded that opportunity. Our attorneys do a really good job of trying to allow that in, but it is often met with challenges from defense. Because again, in the code, there's specific victims that are listed. And so there's a number of obviously rights under 19.2-11.01, but those are the main ones that we are faced with many challenges.
Okay, thank you ma'am. Kelly,
With the hope that this will in fact go to Crime Commission, I just wanted to indicate that as I look at predicate crimes and crimes that you might want to have victims talk, be aware of the circumstances of the crime, I'm thinking of the brandishing a machete that Overchair was kind enough to work with me several years ago. That this is another one of many that is just a misdemeanor, but the intent is far greater than the penalty as far as intimidation.
okay.
So I think the formal motion would be to remove the table, and that staff prepare a letter for me to send to myself, Crime Commission, and we'll take it up.
Maybe not, you're sending it to the chairman.
I'm not chair anymore, you're excited, that's right, send it to the chair. He will then share with me the letter that I sent to him. And we will, what happens is we don't know how many ideas we're gonna get. The executive committee meets early spring, we sometimes have 5 and sometimes have 15. And we just don't know yet whether we're at 5 or 50, this would be right in our wheelhouse.
Thank you. I would love to be invited to that, and like some of my Commonwealth attorneys who are here today.
You and Theo can both come and watch, and it'll be awesome, right? Right? Okay.
All right. There are others here, but I guess.
Okay. Thank you. Okay, all those in favor, well, the motion is to lay on the table, it's a recorded vote, so please cast your vote. So once, close the roll, that bill is laid on the table. Thank you, Kelly.
Chair, there are 3 remaining bills just